The C-SPAN camera panned across room 2154 of the Rayburn House office building. It was 2:47 p.m. on a Tuesday afternoon that would alter American political discourse. Kash Patel sat at the witness table, his posture radiating confidence. His navy suit was pressed to perfection. His leather portfolio lay open before him, filled with battle-tested talking points. Behind the dais, Representative Jasmine Crockett sat quietly, her hands folded atop a stack of manila folders containing a legal trap so meticulously constructed that, once sprung, there would be no escape. The hearing examined constitutional interpretation and executive authority. Patel, a senior legal advisor, defended policies that civil liberties groups warned could reshape America's balance of power. When the committee chair recognized Congresswoman Crockett, seasoned observers leaned forward slightly. They had noticed something about the freshman representative from Texas. She didn't ask questions unless she already knew the answers. "Mr. Patel," Crockett began, her voice measured, "I'd like to discuss your recent statements regarding executive authority under Article 2 of the Constitution." Patel smiled, the practiced, slightly condescending smile of someone preparing to educate rather than engage. Within the next 8 minutes, Kash Patel's confidence would transform into visible discomfort. His prepared talking points would crumble under the weight of his own contradictions. The gavel had struck. The nation was watching. At 44, Patel had cultivated a reputation as one of conservative America's most formidable legal warriors. The son of Indian immigrants, he'd climbed through positions at the Department of Justice, the House Intelligence Committee, and the highest levels of the previous administration. "The Constitution isn't a suggestion," Patel had said at the Federalist Society. "It's a binding legal document with specific meanings that don't change based on political fashion." His supporters viewed him as a fearless defender of executive authority. His critics saw him as someone willing to twist legal precedent. Both sides agreed. Kash Patel was brilliant, prepared, and almost never lost a public argument. He'd spent the previous evening with his legal team reviewing Crockett's background. "She's only been in Congress 6 months," one staffer had noted. What they'd catastrophically underestimated was the 15 years Jasmine Crockett had spent before ever running for office. Representative Jasmine Crockett's office stayed lit long past midnight most evenings. At 43, Crockett had lived several careers' worth of experience. She'd worked through college, then law school at the University of Houston, graduating at the top of her class. Unlike many high-achieving graduates, Crockett chose civil rights law, criminal justice reform, and constitutional challenges. For 15 years, she'd fought in courtrooms across Texas. She'd argued before the Fifth Circuit. She'd challenged voter suppression, prison conditions, and police practices. She'd developed an encyclopedic knowledge of constitutional law and administrative procedure. "The law is a precision instrument," she'd told her legal team. "If you're going to challenge someone's legal interpretation, you have to show them exactly why they're wrong, using their own standards." When Crockett learned Patel would testify, she'd read every speech, article, and legal memo his office had produced. She found troubling patterns: sweeping legal claims unsupported by careful analysis, selective citation of precedent, dismissing challenges by questioning the questioner's expertise. Crockett spent 3 weeks preparing, not talking points, but building a legal case the way she would for court. By hearing time, Jasmine Crockett wasn't hoping to expose contradictions in Kash Patel's legal arguments. She knew she would. The first exchanges were cordial. Patel answered with legal jargon and political messaging, giving opponents little to work with. But Crockett was patient, building foundation. "Mr. Patel, you've stated Article 2 grants the President broad inherent authority that cannot be meaningfully constrained by Congress. Is that accurate?" Patel leaned forward. "Congresswoman, Article 2 is quite clear. The executive power is vested in the President. That's not controversial. It's the text itself. I appreciate that. But do you believe presidential authority under Article 2 is essentially unlimited in national security matters? Patel's smile widened. The president has expansive authority in core executive functions. The founders understood the executive needed flexibility, particularly in national security. Expansive, Crockett repeated. Does expansive mean unlimited? It means what the Constitution says, Patel replied, tone slightly patronizing. The president's authority is checked by other branches, but within the executive sphere, decisions are largely unreviewable. Largely unreviewable, Crockett noted. Interesting phrasing. Patel shifted slightly, the first microscopic sign of impatience. Mr. Patel, I'd like to direct your attention to your memo on executive privilege. Crockett held up a document. You argue the president can assert privilege over virtually any internal deliberations, including potential criminal conduct, correct? That's a simplification, but broadly accurate. Executive privilege protects deliberative processes. Even when involving potential crimes? Patel's expression hardened. What constitutes a crime is subject to interpretation. The OLC has held— Yes, Crockett interrupted gently, holding another document. The OLC opinion from 2000 that explicitly states executive privilege cannot conceal criminal wrongdoing. Were you aware? Patel hesitated, just a fraction of a second. I'm familiar with the full body of OLC opinions. As with any complex legal issue, there are multiple perspectives. Evolving interpretations, Crockett repeated. In your Federalist Society speech, you stated, I'm quoting, "The Constitution's meaning doesn't evolve with political convenience. It means what it says, period." Your words? Constitutional interpretation and application to specific scenarios are different exercises, Patel replied, tone sharpening. I would think someone with legal training would understand that distinction. It was the first direct attack. The suggestion Crockett didn't understand basic legal concepts. Several committee members exchanged glances. Patel's supporters smiled. Crockett didn't rise to the bait. She looked at Patel with calm interest. I appreciate the clarification. You stated presidential authority is largely unreviewable, but the Supreme Court has repeatedly held executive actions are subject to judicial review. Youngstown, United States v. Nixon, Hamdi. Should I continue? Patel's jaw tightened. Of course I know those cases. They address specific circumstances in them. Where the Supreme Court checked executive authority, Crockett interjected, contradicting your largely unreviewable characterization. You're oversimplifying complex holdings. These don't establish judicial supremacy over executive decision-making. Is that your opinion or established precedent? Crockett pressed. It's reasonable interpretation. Based on what authority? Marbury v. Madison established it's the judiciary's province to say what the law is. Are you suggesting that no longer applies? Patel's face flushed. Congresswoman, with respect, you're twisting the law to fit your political narrative. This damages our system. The full attack, an explicit accusation of dishonesty. The room fell silent. You're twisting precedent to score political points, Patel continued, voice laced with condescension. Maybe you need to revisit law school textbooks before questioning constitutional interpretation. He leaned back, clearly believing he'd delivered a knockout blow. Behind Patel, a staffer smiled. Reporters typed rapidly. On the dais, Crockett remained still for 3 seconds. Then she adjusted her glasses, placed both hands flat on the table, and looked directly at Patel. What happened next would break the internet. Crockett's voice was steady, devoid of anger. Mr. Patel, regarding twisting the law and law school textbooks. She opened a manila folder deliberately. I graduated University of Houston Law Center, editor of Law Review. Before Congress, I practiced constitutional law 15 years, arguing before federal appellate courts. I've published 7 articles in peer-reviewed journals on executive power. Patel's expression flickered. Cameras caught it. I don't mention this to boast, but to establish my questions come from substantial legal knowledge. Let's return to substance. She pulled a document. Your executive privilege memo, page 14. The President's authority to withhold information from Congress is plenary and cannot be overridden except in extraordinary circumstances where explicit constitutional crisis declared by judicial authority. Your words, Patel shifted. I oversee significant legal opinions from our office. So you stand by that? Congressional subpoenas can be ignored unless courts declare constitutional crisis? That's a simplification. It's your exact words. Should I read the full paragraph? Unnecessary. I think it is. Crockett read, Congress's investigatory powers, while broad, are subordinate to executive privilege when the President determines disclosure would harm public interest. This determination is committed to the President's sole discretion and is not justiciable. She set it down, pulled another. I'm looking at the Supreme Court's unanimous decision in United States v. Nixon. The court held, neither separation of powers nor confidentiality of high-level communications can sustain absolute, unqualified presidential privilege from judicial process. Silence absolute. Air conditioning hummed. Your memo claims privilege essentially unreviewable. The Supreme Court explicitly rejected that. How do you reconcile your position with a unanimous holding contradicting it? Patel paled. Nixon involved specific circumstances. Every case involves circumstances. That's common law. But the principle was clear. No absolute presidential privilege beyond judicial review. Do you dispute that? I don't dispute the holding. I dispute your interpretation. My interpretation? Crockett's eyebrows rose. I'm reading the court's words. Another document. Your memo on congressional oversight, page 7. Congressional investigations merely exploratory or designed to expose wrongdoing without specific legislative purpose exceed constitutional bounds. Your writing? Our office prepared that analysis. Then familiar with McGrain v. Doherty, 1927? Supreme Court held Congress has broad investigatory authority, including investigating administration of existing laws and probing information for future legislation, specifically rejected narrow view tied to pending bills. She held the citation. The court wrote, the power of inquiry, with process to enforce it, is an essential and appropriate auxiliary to the legislative function. No requirement for pending legislation. Patel tried to interject. In fact, the court repeatedly affirmed broad congressional investigatory powers. Watkins, Eastland, Barenblatt. Should I cite specific holdings? Familiar with them. Then you know your memo's position was rejected nearly a century ago and reaffirmed since. Devastation was methodical, surgical. Directly, Mr. Patel, you accused me of twisting law. I've cited 3 Supreme Court cases directly contradicting your official memos. So I'll ask, have you revisited your law school textbooks? Because your positions were rejected by the Supreme Court decades ago. Patel's mouth opened, closed. No response. Or, Crockett continued, tone softening slightly, perhaps the issue isn't ignorance. Perhaps you're deliberately advancing positions inconsistent with established precedent, hoping political pressure succeeds where legal argument fails. She leaned forward. Which is it? Lack of knowledge of basic constitutional law, or deliberate misrepresentation? The question hung. After excruciating seconds. Legal interpretation involves analyzing how principles apply to evolving circumstances. Not answering my question. Do your memos accurately represent existing Supreme Court precedent, yes or no? They represent our interpretation of precedent saying the exact opposite. Crockett's voice even, words landing like hammer blows. Mr. Patel, the Solicitor General's office must represent law accurately, not just advocate desired outcomes. When you claim presidential privilege unreviewable, that's not interpretation. That's contradicting United States versus Nixon. She held documents side by side. Your words, the Supreme Court's words, opposites. So again, will you acknowledge your office's positions are inconsistent with established Supreme Court precedent? The moment stretched, every camera on Patel. Our positions, Patel finally said, each word costing him, represent our analysis of how precedent should evolve to meet contemporary governance challenges. Should evolve, Crockett repeated. But you accused me of twisting law for political narrative. Now you admit arguing precedent should evolve to fit your governance model? Hypocrisy laid bare. Let me be clear, Crockett said, moral clarity. This isn't Democrats versus Republicans. This is about fundamental legal architecture preventing any president from becoming a king. She looked directly into Patel's eyes. The precedents I cited weren't by liberal activists. They were by Supreme Courts of varying compositions, including conservative justices, understanding separation of powers protects everyone. United States versus Nixon had justices appointed by the president being investigated, still ruling unanimously against absolute privilege. Crockett's voice rose slightly in emphasis. When your office ignores these precedents, you're not just wrong, you're dangerous. Setting stage for constitutional crisis by convincing people in power legal limits don't apply. Stunned silence. Several members, including Republicans, nodded almost imperceptibly. Final question, Mr. Patel. Will you commit today, on record, to reviewing all legal memos to ensure they accurately represent existing precedent, rather than how you wish it would evolve? Patel looked trapped. Agreeing admitted previous work flawed. Refusing admitted no intention of accurately representing law. Long pause. Our office always strives for legal accuracy. If characterization could be more precise, we're willing to review. Not full admission, but close as possible. Thank you. The American people will watch if kept, because rule of law only works if everyone, especially those in power, plays by same legal rules. As time expired, the chair called recess. Before gavel fell, spontaneous applause broke out. Rare decorum violation, the chair didn't stop. Kash Patel remained seated, confident posture gone, replaced by slumped shoulders of someone legally eviscerated before millions. Within 20 minutes, trending everywhere. Within hour, 2 million views. By day's end, 15 million. Response transcended partisanship. Conservative attorney George Conway. I disagree with Crockett on much, but devastating. She came with receipts, cited cases, exposed contradictions, how oversight should work. Progressive Ellie Meistel. Crockett taught masterclass holding power accountable. Didn't yell, didn't grandstand. Methodically used facts, precedent, Patel's words to demolish arguments. Law professors assigned clips. Effective legal argumentation, Professor Lawrence Tribe told Harvard Law. Notice she never made it personal until attacked, then responded with credentials and substance. Networks ran exchange on loop. CNN analyzed citations. MSNBC highlighted Patel's expression change. Fox acknowledged effectiveness. Whether agree with politics or not, respect preparation and knowledge displayed. Political impact significant. Within 48 hours, 3 Republican senators withdrew endorsements for Patel's higher position. Concerns about legal positions articulated, one said diplomatically. Justice Department's OLC announced review of recent opinions for consistency with established precedent. Timing unmistakable. Civil liberties organizations seized moment. ACLU report expanded Crockett's arguments, documenting how Patel's positions could undermine oversight, judicial review, constitutional checks. Downloaded 200,000 times first week. Most significant impact, congressional oversight itself changed. Witnesses noticed members more prepared, substantive questions, specific document citations. "No one wants to be next Kash Patel," a staffer told Politico. "Word spread. Can't rely on credentials and talking points. Better know positions inside out. Someone might have read your memos and checked citations." For Crockett, personally, transformative. Office flooded with 50,000 messages first week. "Registered Republican who didn't vote for you," read Ohio email. "But watching hearing reminded why I fell in love with constitutional law. Thank for principled oversight." Law firms reported surge in applications from young lawyers citing Crockett. "I want to be lawyer who uses law to protect democracy." Common application essay refrain. Crockett's law school applications increased 40% next year, many mentioning her inspiration. School established constitutional law scholarship named for her. Quieter conversations across America. High school civics classes showed clips analyzing arguments. Law school study groups dissected questioning strategy. Coffee shops discussed separation of powers. 6 months later, poll found 67% of Americans who saw exchange felt more confident democratic institutions could function effectively. In deep cynicism era, most remarkable outcome. What Crockett demonstrated, historian Doris Kearns Goodwin wrote, is system works when understanding people do hard work of preparation and principled confrontation. Constitution isn't self-executing, requires constant, knowledgeable defense, ultimate vindication. Year later, Patel's office issued revised legal opinions on executive authority, while maintaining policy positions, reasoning more careful, citations more accurate, acknowledgement of contrary precedent more forthright. "Course correction," noted Professor Michael Dorff. "Not complete reversal, but recognition extreme positions won't survive scrutiny by people knowing law." Late evening, after viral moment replayed millions, Jasmine Crockett sat in her office, processing. Framed Constitution hung on wall, same from law school graduation. Next to it, photograph from first voting rights case. Young attorney on courthouse steps with clients, legal victory protecting thousands of voters. Phone buzzed constantly with requests and congratulations, but notifications off. This moment needed silence. What happened wasn't her versus Patel. Not scoring points or going viral. More fundamental, in America, law applies equally to everyone, and power must answer to those understanding constraining principles. Crockett thought about young lawyers emailing inspiration to pursue public service. High school students shown clips. Citizens feeling hopeless about democracy until seeing moment work. Responsibility humbling. Knock on door. Chief of Staff, Senator Klobuchar, online 2. Wants discussion your testimony judicial nominations. New Yorker wants profile. Crockett smiled. Tell Senator I'll call tomorrow morning. Tell New Yorker appreciate it, but need focus work, not publicity. As he left, Crockett turned back to document reviewing. Another legal memo. Immigration Authority. Hearing next week. Work never stopped. Vigilance maintaining government of laws constant, exhausting. But Patel moment reminded why mattered. Democracy wasn't spectator sport. Constitution not self-executing. Rule of law survived when understanding people defended it. Not violence, but knowledge, preparation, courage confronting power with truth. Somewhere, law student watched clip 10th time, noting questioning strategy. Civics teacher prepared lesson plan around it. Citizen never contacted representative before drafted email about issue, inspired seeing system work intended. Real victory. Not viral moment, but ripples spreading outward, reminding Americans democracy worth defending. Tools to defend it knowledge, preparation, principled courage. Jasmine Crockett picked up highlighter. Returned to immigration memo. More contradictions to find, more accountability to demand, more truths to speak to power. Cameras wouldn't be there for most, wouldn't go viral. But work that mattered. Patient, careful, often invisible work keeping American democracy functioning founders intended. One hearing at a time. One question at a time. One truth at a time. Office lights stayed on past midnight as usual. Because defending democracy never sleeps, and neither do those understanding eternal vigilance is freedom's price. If this reminded why expertise matters, why preparation matters, why democratic institutions work when we make them work, share it. Truth deserves witnesses. Accountability requires audience. Like, share, subscribe, more moments, knowledge confronts power, reminds us in America, law still means something.